In community property states, before dividing spouses' assets upon divorce, courts must classify each asset as either separate property owned by one spouse or community property owned by both spouses. Classification is important because courts generally only have discretion to decide the distribution of community property. In Pereira versus Pereira, we explore one approach used to classify profits from a spouse's business. When Mr. Pereira married Mrs. Pereira in 1900, he already owned his own saloon and cigar business, in which he had invested approximately $15,500 as capital. Throughout the marriage, Mr. Pereira continued to operate his business, leaving the premarital capital invested. The business was successful and provided Mr. Pereira with an income of approximately $11,000 a year. He used a portion of that income to pay the balance owed on business premises. After 5 years of marriage, Mrs. Pereira filed for divorce on the basis of extreme cruelty. When classifying the couple's property, the trial court determined, among other things, that all the profits from Mr. Pereira's business were community property. In an interlocutory judgment of divorce that would become final after 1 year, per California law, the trial court awarded 3/5 of the community property to Mrs. Pereira. Mr. Pereira appealed to the California Supreme Court, arguing that the trial court erred by not allocating to his separate property the portion of profits attributable to his premarital capital investment.